All right. Welcome again to an oral argument session of the Fifth District Court of Appeal. A reminder that this is being recorded on Zoom. That way, when you have parties, you can play it for your guests. The second case that we have on the docket today is 21-798, Prosport Chiropractic and Wellness, Inc. Versus MGA Insurance Company. Joining me on the panel today, I'm Judge Cohen, is Judge Eisnagel and Judge Nardella. This is as close as we get to Groundhog Day, and that we have the same lawyers that we had on our earlier case, and this is a PIP case as well. However, it does have different issues involved than we had in this morning's case. Again, we're just going to shift the parties around, where Mr. Barr now is the attorney for Appellant, and Mr. Dutton will be representing the Appellee. Mr. Barr, there's a 5-minute default on rebuttal. If you'd like something different than that, just let us know. We are happy to accommodate you.
5 minutes.
That said, when you are ready, you may proceed, sir.
Thank you. Good morning. May it please the court. My name is Chad Barr. I have the pleasure of representing Prosport Chiropractic and Wellness in this case. We are asking the court today to reverse the trial court's final judgment in favor of MGA and either remand this case for entry of a final judgment in favor of Prosport or for a resolution on the merits via a jury trial. So the issues raised herein. The last case that we argued, we really lived and died in the PIP statute. In this particular case, we live and die in the facts. And our argument is that the trial court erred when it found that MGA did not waive or was not equitably stopped from rescinding the insurance policy in this case. And really, there were three bases for MGA's rescission of the insurance policy. First, and the testimony in this case was clear that MGA would not have issued a policy at all if it had known that the car was co-owned with somebody else. The second,
and now that fact isn't in dispute, as I understand it. I know that the address, there might have been some disputes as to what they call the garaging, or really the address of the insured at the time of the issuance of the insurance policy. But there is no dispute that the car, in fact, was owned by another entity as well as your client, and that had not been disclosed. Is that correct, Mr. Barr?
Well, so I just want to make one correction. We represent the medical provider in this case.
Well, I understand, but the insured, you know what I'm saying, the insured owned the car with another party, and that had not been disclosed to the insurer.
Correct. And actually, for purposes of appeal, we don't really dispute any of the bases for MGA deciding that it wanted to rescind the insurance policy. Really, the issue in this case is, did they waive the right to do that by taking position or taking action that was inconsistent with its rights when it knew it had that right?
And Mr. Barr, just to clarify a point further, in your initial brief, you say that MGA did not cite any summary judgment evidence in its motion for summary judgment supporting its claim that the alleged misrepresentations were material. But here today, you are not contesting the materiality of the misrepresentations.
Well, it wasn't a point that we raised on appeal, okay, to be quite frank, and I don't see the need in getting into the discussion about whether Mr. Bell's affidavit was correctly referenced, because it wasn't mentioned in the summary judgment motion, but it was filed in the lower court. Really, our key position on appeal is that the right to rescind was waived, or they were equitably stopped from doing so.
I understand.
Okay.
Sorry.
Judge, did you have a question?
Could we, before we get into the what seems to be the big issue of waiver, I would like to just discuss what I think briefly the last argument in your brief, which is that the trial court erred in failing to allow you to amend, correct?
Correct.
I just want to sort of address this first, because I think that maybe we can then focus on waiver. But And the only argument you make on futility is that the appellee did not preserve any argument as to futility. That's the only argument you make in the brief. But the two cases you cite, I mean, and I'm not aware of any cases requiring an appellee to preserve an error. They're all the cases that I'm aware of require an appellant to preserve error. So do you have any cases where preservation applies to an appellee?
Well, I guess the point being was that the trial court didn't rule on that issue, and the appellee did not raise that issue. And so we bring up that issue wasn't raised to avoid the tipsy coachman application of the tipsy coachman doctrine, where they come back and say, well, we argued it, the court didn't rule on it, but we argued it, so it's in the record, so you therefore appellate court can rule on it. The whole point of bringing it up is simply to advise the court that it wasn't presented to the trial court, it's not in the record, so therefore tipsy coachman doctrine doesn't apply, and the appellee cannot rely on that argument.
I mean, I guess when I read this part of this is 2 paragraphs, I read it as a preservation argument. Tipsy coachman isn't mentioned at all. I mean, I'm just trying to get some clarification here.
No, I'm not arguing that. I'm not arguing that. I am arguing that they cannot bring that issue up in the realm of tipsy coachman, because they didn't present it to the trial court, and the trial court did not rule that the amendment would be futile. So our position is that the only basis for the trial court's decision to not allow the amendment was that the amendment would be prejudicial.
But the lower court never, addresses rules on tipsy coaching. That's an appellate concept.
Correct. Correct.
Yeah.
Correct. And again, I simply was saying that they, basically foreshadowing.
You have a case that says that on this procedural posture. I mean, I think that, if it, you have the denial of, your amendment, right? Do you have a case saying that the issue has to be presented to the trial court for the trial court to deny your motion?
I think maybe I'm not being clear. The purpose of that point in the brief is to basically say that appellee cannot argue on appeal an issue that they can't argue that tipsy coaching applies to a doctrine on appeal that was not presented below. So if something is not presented below at all, an appellee cannot rely on the tipsy coachman doctrine. So that's simply all I was saying with regard to that argument.
Okay, that's fair enough. We can move to waiver. I would just say that when I read this, I didn't get tipsy coachman at all. I mean, in the future, if that's your intent, you might actually discuss tipsy coachman and say that, hey, the point of this argument is that they can't rely on tipsy coachman, because I read this entirely as a preservation argument, because those are the cases you cited.
I understand. It's as you probably are well aware, it's hard to anticipate everything, and I appreciate the feedback. I really do. As it relates to the issue of waiver, it's clear in Florida that under 627.409 that misrepresentation in an insurance application may prevent recovery under a contract or policy. We also know that forfeiture of insurance is not favored, especially when the forfeiture is sought after the event giving rise to an insurer's liability. And as far back as 1969, the Supreme Court has held that if an insurer intends to stand on any grounds of forfeiture, it must inform the insured as soon as practical, as soon as it ascertains the facts upon which it bases its forfeiture. And so we have to figure out what is the standard for waiver when we're talking about a rescission of an insurance policy.
But they certainly have to do, a thorough investigation before making that judgment. Would you agree? It's not like, all right, as soon as they have any inkling that there might have been some sort of misrepresentation, that they've got to put the insured on notice. I mean, they've got to make sure that they're on solid grounds for the very reasons that you've stated, that forfeiture of insurance, is not a favored concept. So they need to make sure that they're solid with their argument.
I think solid. I think what the law actually requires is that they have to take affirmative steps to preserve that right if they have actual or constructive knowledge that there is a basis for rescission. And that's kind of what I want to talk about.
But counsel, do they need to act timely with the reservation of rights, or do they need to act timely with the decision? Are you saying that both actions here were untimely, both the issuance of the reservation of rights, which put everybody on notice that we have a problem on these three? Go ahead.
I don't think the reservation of rights issue it bears anything in this particular case. The issue is, what did they do after they knew that they had a right to rescind the insurance policy? And in this case, they continued to require that the insured comply with the terms of the policy. They continued to require the insured to pay his insurance premiums. And what I like to do is kind of take each bite off of each one of the bases for their rescission and explain to the court how they had actual knowledge early on in this case that they had a grounds for rescission, and they acted inconsistently with that right. So for instance, we take this issue of co-ownership of the vehicle. Regardless of whether I agree that the vehicle is co-owned, I don't have a problem agreeing that it was co-owned. But the issue is that they knew as early as January 21st that vehicle was co-owned by the patient and his grandfather or someone else. And so what we know is that they conducted a vehicle registration search. They knew at that point in time that vehicle was co-owned, and the corporate representative testified that they knew on January 21st that the vehicle was co-owned, and the corporate representative testified that if he had identified on the application that the car was co-owned, that they would not have issued the policy at all. So it's not even a question of we have to figure out how much this would be. It's an issue of, would we issue the policy or would we not? They would not have issued the policy. So going back, Judge Cohen, to your question, what does a thorough investigation look like? Not once after that did MGA ask anyone or do any investigation. In the record, there's no evidence that did any investigation regarding co-ownership of that vehicle. The only thing that I can tell you that they did was during the EUO, they asked Mr. Meady, they said, did your grandfather co-sign on the vehicle? That's all they asked. They didn't ask, did you co-own it? Did you own it with somebody? Did somebody else own it? Nothing. And in Florida, I looked it up, there's no requirement that someone who's a co-signer on a vehicle also be listed as a co-owner on the title. So in this case, they didn't do anything further than rely on, and we can go back to the corporate representative's deposition testimony. They asked her, how did MGA confirm that Mr. Necker was a co-owner of Mr. Meady's vehicle? It came out in the searches. What searches? The accurate searches. When was the search done? The search is done January 21, 2014. Question. So MGA was aware on January 21st of 2014 that Mr. Necker was a co-owner of Mr. Meady's vehicle. Yes. January 21st. That's the earliest.
Mr. Barr, what is your solution? Do you suggest that the minute that title registration came back, that they had a week, 2 weeks, a day? I mean, what do you think that they had to cancel coverage or say that coverage was void ab initio? How long do they have to do that?
I think it's a question of fact, but certainly not 4 months. I think if they knew on January 21st that they would not have issued this policy if the vehicle was co-owned, they knew on January 21st, and they took no other action to confirm that vehicle.
At the same time, though, they're investigating the address and what they call the garaging of the vehicle. And is there an obligation to do that in a piecemeal fashion, so that if you have one ground for revision, you must immediately rescind the insurance policy while you then continue to investigate a second independent ground? Or is it not reasonable to wait until you've got all of your ducks in a row and you've done the complete investigation on all aspects of your basis for revision, and then at that point put the insured on a notice?
Well,
I guess to revoke the policy.
I think reasonableness comes down to a question of fact, one, but two, were they really investigating the garaging address? Because what we see in the record here is that the issue came up in the January 28th recorded conversation, recorded statement by Mr. Meady. When's the next time that MGA did anything with regard to the garaging address? It wasn't for 3 months later when they took his EUO. And so we get a phone call. They get a phone call on January 3rd from someone at that address, at the address on the application, who says, we're getting mail here. We do not know who this person is. I don't know what you want us to do about it. And they did nothing for a month and a half. And so the question is, what's reasonable is a jury question with respect to whether or not there's a waiver. The Florida courts have been clear. The Florida Supreme Court, this court, other district courts of appeal have been very clear that waiver is generally a fact question. And in the context of a summary judgment, it should be sparingly granted. And so we're dealing with a situation here where we've got all these facts moving in all these different directions. And not to mention the fact that, and Judge Cohen, I don't understand why, if they had a grounds for rescission so clear as we would not have issued the policy, why that alone wouldn't have stopped it. Instead, the very first thing they do after that is they tell him, we want you to go to an IME. They hadn't even gotten a bill yet.
If they stop it as to the first grounds, then they don't get to ever pursue the second two. If it comes back that the first grounds is no good, then they lose the second two, do they not?
I absolutely
they can't
disagree
investigate
with
them
that.
later.
I would absolutely disagree with that, because they can continue to investigate. Even after the claim's overdue, they can continue to investigate. The law is clear on that. So they can continue to investigate. And they had what they needed. They went to the address. No one, the people living there, said he didn't live there. So they didn't need Mr. Meady to confirm anything further with regard to the garaging address. And again, Mr. Meady confirmed on the January recorded statement that he lived with his mother at the time the insurance policy was issued. So as early as January 21.
They were conflicting. He gave very conflicting information on that.
He was clear on one thing. He lived with his mother at the time he entered, at the time he applied for the insurance policy. So and the corporate representative's testimony was very clear. Every person who lived with him was an additional $11. So $11 is very clear, very simple. He lived with someone. He said he lived with somebody. He said that he co-owned the vehicle. They knew he co-owned the vehicle. All of this was done in January. The question of whether it was reasonable, the amount of time, 4 months, continue to collect premiums. I think all that leads itself to the conclusion that the trial court should have sent this case to a jury trial instead of ruling as a matter of law that MGA did not waive or was not equitably stopped from rescinding the insurance policy. I'll reserve the balance of my time.
All right, I was going to tell you that. All right.
Thank you.
Okay, Mr. Dutton.
Thank you, Your Honor. Let me start with the timeline, because it seems like that's where we were interested. And we talked about co-ownership. Something that manifests itself co-ownership is not the same thing as being co-registered on the vehicle. They're not one and the same. They're not interchangeable. They're not even the same under the statute. So what we had on January 21 of 2014 is what's called an Appellant report, which is a database. We can't get that into evidence. That's hearsay. And the reason it's hearsay is because they say the contributors are unreliable, or unreliable to the point that it cannot be relied upon for the purposes of, in and of itself, establishing a fact. And so what we did with that indicia, and the case also from the perspective of the insurance company, involved a potential suspicious loss on January 14, 2014. So there were a lot of pieces of the puzzle that were in play at that time. So when we then go to the next part and we look at January 28th, we go try to get a recorded statement from Mr. Meady. And as the court has indicated, Mr. Meady, first of all, the recorded statement was not of very good quality. It was garbled. It was almost inaudible, almost undecipherable. But we were able to pick up some additional information from just the recorded statement. But even during this period of time, all of these things that were starting to build into place, Mr. Meady's denying. and he's changing it, and he keeps moving the pieces around to say, well, the information you have or that you're relying upon is not accurate. For example, Mr. Mitty's mother's name is Monique Joseph. And so Mr. Barr today, the plaintiff acts today like that was a known fact. It was not, because when you listen or look at what Mr. Mitty had to say, he also said that he lived with Evelyn Charles out there in Claremont because he wanted the lower premium. Or he said that there was nobody else that lived in the household. Then he suggested where other people live in the household. So it depends upon what day you're getting information from Mr. Mitty and what information and how it conflicts with what you may find in a database, because we kept asking him that particular question. So the key dates so far, just two: January 21, where we have this hearsay accurate report that suggests co-ownership, not co-registration. January 28, with this, again, inaudible, difficult to decipher recorded statement. And then we get an application for Florida no-fault benefits on February 10th. And that lists an address over in Orlando, 1626 Silversmith. So we're going, okay, which one of these is the right one before, and mind you, we're trying to forbear from forfeiting his coverage. We're trying to hold back. We're trying to give Mr. Mitty every benefit of the doubt before we pull back his coverage. But what ProSport wants us to do is, no, pull back his coverage, yank back his coverage right away, right now, when we're still not sure. And so we're investigating that. And also on February 10th was the first time that we received any bills on the case, which is the first time we have a claim set in motion. So then we send insurance information because his attorney's writing to us on February 11th. And we tell for the first time that it looks like there's an undisclosed household member that has been identified. We tell them that on February 11th. On February 28th, we send a letter to ProSport informing them that the claim's under investigation and that coverage for the named insured has not yet been cleared to date. On the same date, February 28th, we send an explanation of benefits regarding payment, stating, please note that the claim is currently under investigation. Coverage for the named insured has not been cleared to date. On February 28th, and Judge Nardelli, you mentioned this, we sent a series of reservation of rights. The appellant here acts like reservation of rights are of no moment. We just need to do away with those. They're of no purpose. They're of no meaning. But we send one, and we tell them vis-a-vis Mr. Mitty's attorney, Mr. King, indicating that we're investigating it. We're trying to obtain all the facts pertaining to it, that we're sending the reservation rights because we believe, and these are the things that are possible. Mr. Mitty's vehicle was co-owned by Necker Joseph, that's his grandfather, and that all owners were required to be listed on the policy. Number two, that there was an unlisted household member, and that included his mother, of course, Monique Joseph, that we talked about, and other possible household members that were required to be listed in the application. And lastly, a possible incorrect address, meaning the garaging address in Claremont versus Orlando, which was inconsistent with his application to write the policy. So the next step is on March 13th, MGA sends another letter to ProSport advising that MGA is investigating pursuant to 627.736 little I. That's something that was put in the statute to extend the period of time when you think there's possible fraud that's involved. And it opens up the window to investigate the claim an additional 60 days. So we tell ProSport that. On March 14th, MGA sends correspondence to Attorney King, informing that based upon Mitty's IME that was performed on March 6th, that chiropractic coverage was no longer going to be extended because it did not appear to be reasonable, related, and necessary. So when we talk about this detrimental reliance, there was no PIP benefits going to be paid based upon the IME as early as March 14th. March 19th, MGA sends another letter to Attorney King, again stating that the claims under investigation pursuant to a reservation of rights, again requesting at this point documentation from Mr. Mitty what documentation, his place of residence before and after the accident, so that MGA could properly qualify your client, Mr. Mitty, for PIP benefits and confirm coverage. We're trying to extend coverage. We're not trying to take away coverage. On April 2nd, MGA sends correspondence to Attorney King saying, yeah, we need to follow up with an EUO expressing that we need to continue our investigation and another reservation of rights. April 28th, we send another letter to Attorney King, again requesting Mr. Mitty to appear for his EUO and advising again of the continuing investigation and a reservation of rights. Each and every time these reservation rights, it says, we're not waiving anything, we're not relinquishing any rights, we're telling you why we're investigating it, we're looking into this so that if we need to extend coverage to Mr. Mitty.
Counsel, I mean, isn't opposing counsel's point that look at some point, right? The reservation of rights becomes meaningless if it's, you know, if, wouldn't you agree that a 5-year delay, the reservation of rights probably wouldn't save you from a 5-year delay?
It would depend upon the facts in between, but probably the facts in between would not support.
Give me some facts that where you would still prevail with a reservation of rights after 5 years. Just give me any hypo.
That there's been fraud, that there's been deceit, and all of a sudden that we received some information down line that there was originally fraud or something wrong that was not there.
But that wouldn't be a 5-year delay, right? I'm talking
I
about.
wouldn't think so. That's why.
I'm talking about a situation like this where you get the information.
Oh no.
You say, oh well, maybe we have a problem. You send the reservation of rights, and then 5 years later, you finally take action.
Yeah, I wouldn't disagree with you under the scenario that you're posing.
Reservation of rights doesn't help you there, right?
It probably would not help you there. It would expire because it would be way beyond a reasonable time in order to continue to, if you will, reasonably investigate the claim. So I would agree with you under that scenario. Here, we're only about 30, maybe 60 days tops into this thing, still trying to put together the pieces of the puzzle because Mr. Mitty is throwing pieces at us that fit his scenario where we're trying to get the pieces to go, do they fit or do they not? And so we're asking for the investigation. We're asking for the materials. We're asking him first to set for the recorded statement and then to clarify, because a recorded statement, with all due respect to the court, is not admissible evidence if we're going to go forward on a material misrepresentation claim. We need sworn testimony. And so we need the actual examination or oath, that is a statement by the insured telling us something that's false and untrue, that's inconsistent with the application. So each and every piece and part of this as we go along, again, and I understand, Judge Hasnagel, that we're talking about a long period of time in your scenario. This is a very, very short, compressed period of time where, again, the insurance company is trying to do everything it can to extend coverage to him.
Mr. Dutton, I want to ask you about the reliance element for the affirmative defense. And I read the initial brief as arguing reliance, that Mr. Mitty relied. Do you agree that we look at Mr. Mitty's reliance, or would you argue that you look at whether or not Pro Sport relied to their detriment?
I would say that you look at Pro Sport, Your Honor. We mentioned that in our briefing, that and there's no evidence of that. And to follow up with you, Judge Nardal, find that evidence in this record where it says, whether it's Mr. Mitty or whether it's Pro Sport, relied to my detriment. And I did this and this based upon what you told me. It doesn't exist in this record.
Well, more interestingly, is there any evidence in this record that Mitty relied to his detriment?
No, ma'am.
Any evidence that he paid bills and would you agree that that's the sort of evidence that you would need in the record to show detrimental reliance? Is not that he was on the hook for bills possibly, but they were actually paid?
It's their burden, and they allege it as a reply in their affirmative defenses. And so therefore they need to come forward with, number one, and going back to Judge Eisnagel, what you said, an intentional relinquishment. Reservation rights letter under this period of time is certainly not that. But number two is that as you point out, that they relied to their detriment. Again, I'm going to repeat, there's nothing in this record that the plaintiff has carried their burden to show whether it's Mr. Mitty or whether it's Pro Sport, because if Pro Sport saying that, I want to circle back to the IME. The IME was an IME cutoff regarding treatment. So there's no way in the world that whether it's Mr. Mitty or Pro Sport could come back and say, oh yeah, I relied to my detriment that I guess I continue to treat Mr. Mitty. That's why I focus more on Pro Sport under this scenario. And so on April 28th, we sent another letter to Attorney King requesting Mr. Mitty to appear for the EUO on May 8th. He then appears for the EUO, and during the EUO, he testified that his current address was 1626 Silversmith Place in Orlando, not Claremont, and that his mother, Monique, had lived at that address for 4 or 5 years. Mitty testified that he just moved back with her in the past 3 months. He testified that his mother owned her own vehicle, which is important to the underwriting. He testified that his mother's boyfriend also lived there on and off, which would be relevant, and had his own vehicle. Then he testified that he lived at 2613 Renegade Drive, that's in Orlando, for 3 years prior with his mother. He testified that he lived at 3301 White Blossom before then, and that perhaps when he was a kid at the time, when he was 13 years old, his mother moved to 2613 Renegade. He then testified that he put in 3301 White Blossom Lane in Claremont on his application because that's where he, quote, used to be most of the time. And that's where his mother's mail was sent. He testified he physically lived at 2613 Renegade Drive at the time, but that his mail went to 3301 White Blossom. He testified that his aunt, Evelyn Charles, lived at 3301 White Blossom. And he testified that he always lived with his mother at one place or another, and testified that he not list his mother on his insurance company because he didn't live there. Testified he didn't list his other family members who lived in the house. There's a lot more things that he continued to say, for example, regarding the co-ownership. Testified that his grandfather, Necker Joseph, co-owned the car. He testified that he was employed at the time of the accident Cheesecake Factory, but he didn't lose time from work. But later he testified that he did. Testified that he'd never been in a prior accident. And the bottom line is that depending upon when you ask him or how you ask him, Mr. Mitty said different things in his assertions, in his recorded statement, in his EUO. And so finally, and I say finally, on May 30th, 2014, just a couple months after we start into this investigation, go, no, we're denying coverage and rescinding the policy based upon the material misrepresentations in the application, both as to the co-ownership of the vehicle, number 2, as to the garaging address, and number 3, as to other drivers or occupants of the household that you failed or refused to disclose. And so if you look at the testimony that the appellant referred to here, she actually, the claims representative or adjuster in the case, gave great testimony, and it starts on or about age 16 or 17 and talks about the investigation. And it said their investigation talked about the garaging issue, that also unlisted household members, and also, according to the underwriting department, what they had to do to get there, because it's not a simple 1, 2, 3 step. It obviously has to be something that between the claims department and the underwriting department, they have to look into and research. And so I see I'm coming up on the 4-minute mark. I do want to point out some of the law that was cited. And so there's a lot of reliance upon cases that really don't or are not similar. One that we often see in these cases, the Johnson Life Insurance Company case, and that case had to be an agent of the insurer accepted an application knowing that this person had been to a tuberculosis sanitarium. And notwithstanding that they had actual knowledge, and it talks about that, that case talks about full knowledge, with knowledge that he was uncontroverted, that he was not in sound health, they'd actually received treatment for tuberculosis, that it was in the knowledge of the agent, and that they acted with full knowledge and with deliberate disregard of the actual knowledge that they had. That's not this case. This case is one where we had certain potential markers that would allow them to rescind the policy. And that's why in our briefing, and in our answer brief on page 33, we talk about waiver as the intentional relinquishment. There's no intentional with all the reservation of rights. It does not arise from, quote, forbearance for a reasonable time. And Judge Eisnagel, that returns back to you, a reasonable time. And is 2-3 months a reasonable time for investigation? You would hope that your insurance company, not you specifically, but the big U for insurance, would hope their insurance company would exhaustively investigate a claim before they would pull back the rug of coverage. And as the plaintiff, as the appellants repeatedly state here, result in forfeiture of coverage. MGA didn't, and now they're being criticized for it. In addition, we pointed out a bunch of cases because there weren't really good ones in this jurisdiction, but we found some really good ones in other jurisdictions. And again, on page 33 of the brief, an insurer has the right of a reasonable time to investigate the possible rescission and assert the claim, ruling that a party claiming waiver did not establish the insured acted unreasonably in a 6-month investigation. And it does a deep dive, and this is an Aetna casualty and surety versus retail local 906 of AFL-CIO, and finding no waiver where there was 1 year passed between the time insurer first had the information bearing on possible rescission and the insurer's rescission. It says, indeed, public policy supports the allowance, if not the requirement, of a reasonable investigation. It would be unwise to give insurers an economic incentive to rescind insurance at the drop of a hat and without sufficient investigation. Recognize that rescission is a drastic remedy and a ruling that an insurer awaited the conclusion of the investigation and the advice of counsel, in this case, co-acting with the underwriting department. Taking all things into consideration, we respectfully submit that the court looked at this and said, yes, there's no question of material fact here. There was material misrepresentation, and you haven't done enough to carry the burden of proof. Lastly, regarding the amendment, the amendments of no moment. In fact, what the argument was in the cases, and the one was a Bloodworth, and more recently, there's one from the Second District Court of Appeal that came out on April 22nd, and that's the Century National Insurance Company case, that they were trying to argue that 30-day window is it. The 30-day window to pay a claim under the PIP statute opens, and then it closes, and even if you have a basis for rescission, too bad, so sad. And so the cases that we cited, the AFO case and also this more recent case from the Second District, both say not so much.
Thank you.
So again, we request the court to affirm the trial court. Thank you.
All right, Mr. Bauer.
Thank you, Judge. What's always interesting to me is to hear the arguments that come from insurance companies when they try to paint themselves out to be the knight in shining armor in this case, trying to find coverage for this individual. And the reality is we don't have to look much farther than the answers to interrogatories, which state that they knew on January 21 that this policy should not have been issued. Look past the responses to requests for admissions, which state that they knew on January 21 that this policy should not have been issued. We don't have to look much farther past the deposition of the defendant's corporate representative who testified that they knew on January 21 that this policy should not have been issued. The problem with Mr. Dutton's argument is that he's asking this court to find as a matter of law that an insurance company can investigate for as long as they want, so long as they think that there's a reason out there. And we've seen that the courts have extended that investigative period as it relates to the 30 days. And I understand that ruling. But as it relates to when you have to put your foot down and make a decision with regard to a rescission, they were not investigating the co-ownership issue. Mr. Dutton read to you.
When they put their foot down, and this is my question, when they put their foot down, is it more than just we know? At that point, when they put their foot down, don't they have to be able to say, we can prove this in a court of law? Do they get a time period? I think that's the argument Mr. Dutton's making, is that, we get a reasonable time period, not just to say, we think this, it looks to be this way, but when we get sued, because that's what's going to happen when we rescind this policy, we're going to get sued. What can we prove in a court of law? Do they get to use those tools to do that, to gather that information so that they could make that case?
Well, I think the problem in this case is that wasn't important, because they knew in January of this issue. They didn't take the EUO until May. The very first thing they did, the only thing they were concerned about was cutting off medical benefits, which is why they sent him to an IME first.
But they tried to take
Have you ever seen Training Day?
I don't think I have.
All right, where it's a Denzel Washington line. It's not what you know, it's what you can prove.
Well, I think that they had enough, because they've got his recorded statement. They have their searches. He never once denied that he co-owned the vehicle. Never once denied that. But he wasn't asked that again after January 1st until his deposition testimony. He wasn't asked that again. So if they were so concerned about that issue, as we don't issue a policy if there's a co-owner, why didn't they ask him about it again until his deposition years later? So they knew, corporate representative has confirmed that they knew in January, and they continue to collect his premiums. And the issue is now he's operating, and Judge Nardella, to your question earlier, we stand in the shoes of the insured. So the detrimental reliance is as it relates to Mr. Meady, not ProSport. And in this particular case, what you have is this continual recirculation of information saying, you have to act pursuant to this policy or we're going to deny your claim. You have to act pursuant to this policy or we're going to deny your claim. You have to pay your premiums or you're not going to have coverage. It's continual reliance on the assertion that there is a policy in place.
Fair enough, but how did he rely to his detriment? He got his premiums back.
Again, the issue here is whether or not MGA was entitled to summary judgment, not whether I can prove my affirmative defense to a jury. He continued to treat, incur medical bills, continue to pay insurance premiums, and continue to operate as if they're and comply with a policy that ultimately MGA pulled out from underneath them. So
thank you, Mr. Barr.
Thank you.
All right. Well, thank you both for your arguments. Mr. Dutton, Mr. Barr, thumbs up, thumbs down on headset and microphone? Make a difference one way or the other?
To be honest with you, I think you sound exactly the same.
Okay.
I think you're actually more audible without the headset.
Okay. All right. Well, I'm certainly
you're crystal clear on
certainly
this.
Better looking without it. All right. Thank you both for your input. Thank you for your arguments. And the panel at this time will go ahead and we're going to go into conference over these cases, and we'll get decisions to you promptly. Thank you both.
Thank you, Your Honors.
Okay.
Bye-bye.